We have come to celebrate this document in my hand. This is the Constitution of the United States. This Constitution we celebrate today is a celebration of 4,300 words. The 4,300 words or 4,300 words that changed and built the greatest republic on earth. It is the celebration of 4,300 words that established the structure of the United States government, that established 3 branches of government: the executive, the legislature, and the judiciary. Today, the court has moved from Topeka here. I recall while I was in the law school in Africa, one of the earliest cases we did in the law school was Brown versus Board of Education of Topeka. So Kansas offers that to the world. But before we call on the judges for the court to call the court in session, I have the pleasure to introduce to you our new president, the president of Kansas City, Kansas Community College, Dr. Doris Givens. Could you please stand up for us to recognize you? Sorry, I mean Dr. Givens should please stand up. Thank you for standing up. Yeah. Dr. Givens, please stand up, let them know you. I'm sure some of the students have not seen you. That's your new president. That's your new president. We also want to recognize the vice president, Mr. Brian Bode. Is Brian here? Okay, good. The president, okay. We want to recognize our provost, Dr. Tamara Jaffa. Is she here? She's right here. Oh, please, let's behold our provost. I am not trying to discriminate because this is a law court before I'm tried, put on trial. But can I recognize the Dean of the Social and Behavioral Sciences who has all along piloted everything about this Constitution Day? It's under his lap. Dr. Chuck Wilson. We invited the mayor of the unified government, Lansing Edwardville. If you're a mayor, please could you stand up and let us recognize you. Let me finally recognize the deans, the great deans who have been doing such a wonderful job for us here. Who are the deans, please? Any dean present, can you stand up for us to recognize you? That's the Dean of Business, Dr. Marvin Hunt. Thank you, welcome. Well, without ado, I have the pleasure to hand over this session now to the court. Thank you.
All rise. The Kansas Court of Appeals is now in session. The Honorable David E. Brunn is presiding.
Please be seated. Good morning, and once again, welcome to this special session of the Kansas Court of Appeals in celebration of the 224th birthday of the United States Constitution. As a graduate of Kansas City, Kansas Community College, it's a particular honor for me to be able to preside today and to sit with two of our fantastic judges. To my right, the Honorable Michael Boozer, and to my left, the Honorable David Knutson. With that, counsel, whoever speaks first, Mr. Gillette, are you speaking first?
I think so, Your Honor.
Okay. When you do, turn the podium towards us, if you would. Each side has 15 minutes to argue. The appellant has the opportunity to request a portion of the time being preserved for rebuttal. With that, court calls the case of State of Kansas versus David M. Butts. Would you please state your appearances?
May it please the court, your honors, the state of Kansas appears by Jennifer Tatum, assistant district attorney in Wyandotte County, Kansas.
Good morning, your honors. May it please this esteemed court, David Butts appears personally today. He's in the front row, your honors, as well as Ed Gillette, counsel, and Mike Mogensen, co-counsel.
Mr. Logerson, how do you spell your last name?
M-O-G-E-N-S-O.
Thank you. With that, Mr. Gillette, are you ready to proceed? And would you like to save any time for rebuttal?
I would, Judge. 5 minutes, please.
That's fine.
Judge, let me first say that I, too, went to the Kansas City, Kansas Community College, and I am a resident, long time of Wyandotte County, Kansas, and I'm glad to be here today. In addressing the court, clearly the issues are succinct as presented in the brief by the appellant, Mr. Butts. This was a case that your honors obviously are familiar with based upon the review of the briefs. This was a situation that occurred in Wyandotte County, Kansas, and to be precise with the court, in this particular case, Mr. Butts was operating a vehicle late at night, was stopped allegedly for speeding and failure to maintain a single lane. The officer candidly admitted later that he was wrong, that the failure to maintain a single lane did not meet the statutory definition. So consequently, then we deal with the issue of speeding. The officer said, I couldn't get him on radar and I didn't pace him because I was going the opposite way. At some point in time, though, the officer did effectuate the stop based upon those two circumstances. Thereafterwards, as the briefs indicate, Mr. Butts allegedly had an odor of alcohol. He stumbled getting out of the car, etc. Unfortunately, we don't have any videotape of that, which I think is the best evidence in this particular case. It was there, gone, for some reason disappeared. Having said all that, in this particular case, Mr. Butts, ultimately, it was determined that there was cocaine on his person, and he was charged with possession of cocaine as well as DUI. We initially had the arraignment in this matter after preliminary hearing. And I think it's important for the court to recognize that we're talking about 183 days as far as speedy trial, but the court should recognize that actually the trial date was 258 days after arraignment. If you'll look at the graph that we have provided to the court, it specifically details the time that we believe is calculated to the state as well as to the defendant. But I don't want to get ahead of myself here. I think it's important for the court to recognize in this particular case that probable cause nor reasonable suspicion existed in the first place to stop Mr. Butts. It was effectuated after the stop, and specifically, our brief indicates that we believe that the police officers in this particular case created a situation to say, hey, the stop should be based upon a DUI, but the DUI did not occur until after the stop occurred.
So, Mr. Gillette, your client argues that it was a pretextual stop, is that correct?
Yes, sir.
And the officer did have an opinion as to the speed of the defendant's car?
He did, Your Honor. And
tell me if he had an opinion that the defendant was speeding, doesn't your issue really go to the weight of the evidence rather than a legal issue?
Well, it does and it doesn't. And I understand the court's question, and I figured I'd get that. But here's the problem we've got. The officer's going one way. Mr. Butts' vehicle is traveling the other way. It's almost 3 o'clock in the morning. It's not lit. Nobody else around. And the issue then becomes the officer says he turns around, and then he followed Mr. Butts' vehicle, and in fact, he was not speeding. When he was able to pace his vehicle, he was doing the speed limit. And our argument very simply is it's appropriate for the officer to make that statement given the fact that ultimately there were certain instrumentalities and fruits of a crime discovered on him. We suggest to the court that not only does it go to the issue of credibility, but it also goes to the initial stop in the first instance, because in fact, the pace supported the fact that Mr. Butts was traveling the appropriate speed limit.
Let's just kind of set the constitutional law framework, it would be improper and illegal for a police officer who does not have reasonable suspicion of a crime to stop that vehicle, correct?
That's our supposition, Your Honor.
And if the officer did that, then any fruits of the stop, the search, drugs, whatever, would be suppressed under the Constitution, the exclusionary rule.
Absolutely. Fruit of the poisonous tree, Your Honor.
So the question is, did the police officer have reasonable suspicion to believe that your client was going 45 and a 30 as the car was traveling away from the officer?
And that's exactly a good point, that I'm glad that the court brought that up. How do you come up with 45 and a 30 when you're going one way and you're allegedly the police officer going the appropriate speed limit, and he gauges my client's vehicle at 45, even though there's no radar, there's no pace, and when there is pace, it supports the fact that Mr. Butts is traveling the appropriate speed. So our supposition and our claim in the first instance is that there was no basis to stop Mr. Butts' vehicle, and once the vehicle was stopped, the cocaine was found, the evidence of the DUI came about, and at that point in time, from the video that you can hear, there is discussion about, well, how will we frame this? How will we go ahead and indicate the basis for the stop? And one of the officers says, well, we'll claim it's DUI. Has nothing to do with the speeding, has nothing to do with the failure to maintain the single lane. And the state conceded in their brief that failure to maintain single lane is not an issue at this point in time. And that's one of the problems clearly that the defendant has in this particular case.
But you point out in your brief, you haven't mentioned it here yet, but the fact that there were other officers who were staking out the residence where your client was coming from, believed to be a drug house. And so the overlay here is not just that there was not reasonable belief, but that there was a pretext, that this was a phony stop because they thought since he's coming from a drug house, we'll stop him and find drugs in his car.
Well, and that's absolutely correct, Your Honor. In this particular case, Mr. Butts and the co-defendant, Mr. Forbes, were at a alleged known drug house in Kansas City, Kansas, and that particular place was being watched by Vice Narcotics here in Kansas City, Kansas. They left. They didn't observe any trafficking going on in plain view, so consequently the officer radioed to another officer. They had been at a drug house, and that's when the officer who made the stop of Mr. Butts said, hey, I did it based upon speeding, which I can't support, and failure to maintain a single lane, which clearly doesn't meet the statutory definition. So that's correct.
Mr. Gillette, let's talk a little bit about the speeding claim. Is it your position that it takes a radar or an expert to calculate the speed of a vehicle?
No, I'd like it to be, Your Honor, but in this particular case it can't be, and I think that's what the state relied upon. It's based upon the officer's observations in his 3 years of experience as a law enforcement officer. I've been practicing law 27 years. I can't gauge the speed of a vehicle, and I do this every day. And it's amazing to me that an officer can come into a court of law and specifically say 45 miles an hour was what this individual was traveling.
Have you ever defended a case where the state presented evidence that the officer comes up and says, in my opinion, based on what I know, that the defendant was going 45 and a 30 and the court found your client guilty?
Oh, of course. Absolutely. And in this particular case, I submit to the court that what we have is a factual disagreement as to A, the speeding, and B, the level of the speed. But having said that, I'd like to move, if I can, to I think what I believe is the most important argument that the defendant makes in this particular case, and that's speedy trial. In this particular case, we know that the defendant is guaranteed the right to a speedy trial within 180 days of arraignment. Arraignment occurred the day of the preliminary hearing when the defendant was bound over. And as I indicated to the court, 258 days had run from the date of arraignment to the date of trial. The defendant was well aware of that. It wasn't like we knew at the last minute that something was going to happen and that it dawned on us that speedy trial somehow had run. We were aware from the get-go that when we filed a motion that the time would be counted against the defendant for speedy trial purposes. In fact, we filed the motion to suppress early. And once we did that, then the state came in and asked for the continuance. Then the court took a look at it and said, I will rule within 24 hours. That 24-hour period of time turned into about 2 months, almost 3 months. And at some point in time, speedy trial began to knock on our door, and we said, possibly in this particular case, Mr. Butt's time for speedy trial purposes will have run. Once the particular motion was ruled on April 30th, we assumed that the court would go ahead and immediately set Mr. Butt's case for trial based upon the fact that Ms. Tatum, the defendants, and the defendant were all aware of speedy trial. But it didn't happen. It happened on May the 10th, and we calculated that time, and that's when we came up with the 183 days. And the state wants the court to give Judge Boating a certain amount of leeway. I don't have a problem with that, but in this particular case, it was an extreme amount of time, first of all, and furlough days shouldn't be counted, second of all. And I was concerned when the legislature passed the furlough issue that this may come back to haunt a defendant. In this particular case, it did, and the state's relying upon that now.
So, Mr. Gillette, I want to make certain I understand the argument. Looking at the chart, and this may not exactly line up with your chart, but from February 2nd, 2010 to April 30th, 2010 was the period of time used by the district court to render a decision on the motion to suppress, which is 88 days, correct?
Well, as I've got it, Judge, in my brief, 2/10/10 to 4/30/10.
Right.
That's correct.
88 days. And are we, is all of that time attributable to your client?
Well, I don't believe so, Judge.
As to the issue before us, are we counting days within that 88 days?
Well, Your Honor, it's my understanding that once the court on December 11th continued the motion for the state so that they could have a witness in there,
okay.
We then heard it on February 1st. The court then indicated, and it's contained within our brief, I'll have a ruling within 48 hours for you.
Well, setting aside the furlough issue, there is a component of time that you wish for us to consider within the 88 days.
I think all that time should be counted against the state,
And
Your Honor.
also, you're talking about the time from May 1st to May 10th.
Yes, sir. Yes, sir.
So you want the panel to consider carefully who should be charged for roughly 98 days.
That's correct, Your Honor. And I think the state attempts to make that argument in their brief, but it strikes me as masking the real issue here. The state has the burden of bringing the defendant to trial. The defendant does not have to bring himself to trial. And the state clearly was aware, as well as the defense, as well as the court, speedy trial purposes. And it didn't happen. And so consequently, we filed that motion the day of trial, indicating to Judge Boating that in fact 183 days had run, 3 days beyond speedy trial, and that the case should be dismissed.
Mr. Gillette, just so you know, you're at 11 minutes.
Okay.
But
Your Honor,
before you go,
Yes,
I've got
sir.
a couple questions for you.
Sure.
And we will
We'll accommodate you.
accommodate the time.
You don't like the amount of time that Judge Boating took to make his ruling, to look at the evidence, to view the videotape, and you think it was too long?
well, you know, I don't want to comment on that. Here's what I think. I think that the Supreme Court in State versus Roman says an appropriate amount of time is 2 to 3 weeks.
And that's my question to you. The Supreme Court has said in one case 2 to 3 weeks is appropriate. Is 2 to 3 weeks appropriate for you?
Not in this case, and let me explain to you why. State v. Vaughn, which is a case I took to the Kansas Supreme Court. I represented the chief of police in Edwardsville. In that particular case, the judge in that case took months to decide an issue. And the Supreme Court sent it back to the district court to determine whether or not the district court, we had acquiesced in the continuance. And obviously they found we didn't, and the case was dismissed. But my point here is that had we filed our motion to suppress at the end of the 180-day period, then I would say to the court, and we wouldn't even be here at this point in time arguing this, that, hey, it's our fault. We waited too late to file the motion to suppress. We waited till the end of the speedy trial time. We didn't do that. In fact, we filed it early, back in October, and this case still wasn't set for trial until May of the following year.
So even if, regardless of what time the court takes this matter under advisement, depends on how much time you give the court to rule?
Well, I think it's important for this court to make a determination as to whether or not the motion was filed in a timely fashion, and we believe it was. And second of all, I think if it wasn't filed in a timely fashion, then the court's entitled to a certain amount of time. But the court had that in this case.
Okay, my last couple questions. You are raising a speedy trial argument under the Kansas state statute, correct?
Yes, sir.
And that takes a look at the time from the time a person is arraigned, read the charges, until the time they get to trial.
Correct.
And your client was on bond, therefore the statute, Kansas legislature gives them 180 days to have the state, Ms. Tatum, bring that person to trial.
That's correct, Your Honor.
Now, you haven't raised this claim as a constitutional claim under the U.S. Constitution.
Well, we did. We raised the Fourth Amendment and Section 15 of the Kansas Constitution both initially in our argument. I don't know if you saw that, but
I didn't see anywhere, I mean, the landmark case on that, as you know, is Barker v. Wingo, and that would take a look at a much broader span of time, which I thought you were alluding to when you began your argument, to over 200 some days that it actually took for the entire completion of this litigation.
Well, I am and I'm not. I'm still indicating to the court that initially when this thing occurred, when Mr. Butts was arraigned, 258 days ran to the date of trial. But what I am arguing to the court is forget about the 258 days. This wasn't a little tight area where we had on the 183rd day after arraignment, we moved for a dismissal. It was 258 days, and of that, 183 had run against the state.
Thank you, Mr. Gillette.
Thank you.
Ms. Tatum?
May it please the court. With regards to the first issue, the Fourth Amendment issue, appellant tends to focus on the speeding aspect of this, but it was clear when the officer testified, and he did testify twice. He testified once at preliminary hearing and once at the motion to suppress. It was clear that he factored in other things into his decision to stop Mr. Butts, other than just the speeding and the improper lane violation. In fact, he testified twice that one concern of his was the early hour of the morning. This was at approximately 2:48 a.m., I believe, in downtown Kansas City, Kansas, near 18th and Minnesota. He factored that into the mix. He also factored in the weaving within the lane, and he was quite candid about the fact that later on he was wrong. I believe that's a good faith error. A good faith error cannot give us reasonable suspicion, but just because